So, hi, John Miller, as always, founding attorney, Rock Solid Law. So good to be with you. I hope everybody's staying safe. I know the news here at the beaches has been a little difficult in the last few days, so I would urge all of you to continue proper physical and social distancing. This isolation can be no fun, but I think it's so important and it's so much better than being sick. So thank you for spending this little bit of time with us. Today we're going to talk about another in our series of estate planning issues, and as you know, because you signed up for this, today it is called Funding a Trust. What the heck does it mean to fund your trust? Just last week, I consulted with a delightful couple who had done almost all the right things. They had put into place a will and a living trust so that they'd make things easy on their children, their heirs, after they were gone. This would avoid the cost, expense, delay, publicity, and hassle of a probate lawsuit. Now, if those subjects I just whizzed past are try that again, John, are at all of interest to you, there are at rocksolidlaw.com/videos of the previous Zoominars that we've done, and discussing the subject of what a trust does for you will cover those subjects. Go look at that anytime you want. It's going to be there and available for you as long as there's an internet and as long as we're around to try to help educate you. So they did everything just about right. But, and I see this all the time, they failed to fund their trust. So if they passed away before they came to consult with me, their trust would have been totally defeated and their estate would have been probated. That means a lawsuit would have been filed, a judge would have been in charge, a personal representative would have been paid, and their children, their kids would have inherited 5 to 10% at a minimum less than they'd planned. And in fact, statistics show that they probably would have inherited 30 to 60% less in the end, total overall estate, which is through the death of both parties to a marriage. And this happens like 80% of the time in America because people don't get their trust done and they don't get them funded. So, excuse me. What does it mean to fund your trust? All of you who have been on this series know that there are terms of art in estate planning and indeed in the whole field of law that I think are completely useless, right? I know a Boston lawyer, very fond of him, who says that we lawyers like to sprinkle Latin into our phrases like so much salt and pepper, mostly just to impress ourselves. So funding to me is one of those items. You see, for a trust to be a viable entity, for it to have life breathed into it, and for it to have its own life, which extends beyond that of our own, something must be transferred into the trust. The trust has no meaning if it doesn't have assets inside it. The act of transferring assets into the trust is known in estate planning as funding. It's that simple. Why we call it funding, I have no idea, because as some of you that are on this Zoominar know, sometimes it's not very fun. So funding the trust, right? Transferring assets from your individual names or from some other entity, could be in another entity, into the trust gives the trust its viability. It becomes, I like to think, a breathing entity of its own. But there are many, many different types of assets. And as many types of assets there are strategies for placing them into the trust. You see, the trust is the thing that's going to govern, where you govern what happens to what you've earned after you're gone, right? Not just in the immediate sense, but over a period of time. A will can do it for the immediate sense through the court. A trust can do it through your trustee over a period of time. So I might have had another client recently who just adores her son, but really doesn't want him to, and I quote, piddle away everything that he would receive if she were not here before he's 40. So she's going to make a barrier out there, allow the trustee to get him what he really needs, but not allow him to get his hands on everything until he's 40 years old, at which point he will either make good life decisions or will run through the assets the way she knows he would as a younger man. You probably notice I always throw the sons under the bus during these webinars. It's the easy thing to do, but in this case, it's truly the situation. So what are those strategies? So sometimes after discussion with you, we intentionally leave an asset outside of a trust. Maybe you want a certain life insurance policy to go to a certain person immediately. Or you might put them on title to a deed so that that piece of real property goes to them immediately upon your death. So we're going to examine your personal, own, specific, individual situation and decide what's going to go in that trust, right? So let's talk about some of the common types of assets which may go into a trust. And one of the easiest ways I think of doing it is to, from the start, answer the question of what doesn't go in a trust, right? Everybody always wonders about qualified plans. IRAs, 401ks, SEPs, all of those kinds of things. By law, it's best to leave titled in your individual name. They are not owned as an asset of your trust. However, we want to change the transfer on death, TOD, or payable on death, POD, language to go into the trust. Why? Because you've said within the body of the trust how you want your assets treated after you're gone. So they will become, after you've used them throughout your life, whatever's left over will become part of the, we call it corpus, body, assets of the trust, so that they can be administered by your trustee according to your directions and only within the powers that you've chosen to give that trustee, right? Bank accounts, those kinds of things, savings, checking, CDs, all of that. Yep, we can title that in the name of the trust. Brokerage accounts, non-qualified plan type, yes, of course. Those are going to be transferred and owned in the name of your trust. Stocks, bonds, those sorts of things, absolutely. Transferred into the name of the trust. The trust will own it. It becomes an asset of the trust to be distributed after you're gone. And of course, guys, remember from the trust hour, trust session, trust Zoominar, you maintain complete control over that during your life because you've named yourself the trustee during your lifetime. Your interest in a business, an LLC, a corporation, or partnership should be owned by your trust. Real property, in most instances, should be owned by your trust. As in all of these categories, there are exceptions, all based on the facts of your particular circumstance. Notes receivable. Somebody owes you money and has signed a promissory note. You want to assign that into your trust so that it can collect it if you're not around to do so. Tangible investment assets. I love this one. This, we're going to do an assignment of all of your property into the trust, right? But tangible investment assets is like cool stuff you own, all right? Gold bullion, silver coins, art objects, that Rembrandt that your grandmother gave you. In my case, a few of my guitars are particularly valuable, and I'm going to determine where and how they go. They will not be sold during my lifetime. I've declined that many times, but I want them to be treated well after I'm gone as well. So those special things that you own, and for every person is different, but I'd say $5,000, $10,000 in value and up. You want to make sure that those are properly transferred into your trust. I got ahead of myself on personality. That's your personal stuff. We're going to transfer that in there. And then Life insurance and annuities. See how I sandwiched this? They're another category we don't transfer the ownership in there. However, in most circumstances, we're going to put the death benefit of that annuity, if there is one, the death benefit of that life insurance through the trust, because that's the container through which you are going to manage all of your assets. So basically, whoa, John, what is all of that? I know, it's a lot, but it's the right thing to do. It's the mature thing to do. It's the grown-up thing to do, and it's the best thing for you to do so that you don't leave a mess behind, so that your legacy can be celebrated, and so that all that is yours goes exactly in the manner in which you wish for it to go after you're gone. So basically, you have two choices. You can try to transfer the assets yourself, and should you choose to do that, you will receive from us an instructional letter like this one, properly redacted so you can't see who I'm talking about here. And it's going to tell you all of those categories we just went over and more, and give you specific instructions on how to transfer different types of things into your trust. Your second option is to hire us or some other practitioner in estate planning to assist you in doing that. A lot of times folks will say, I think I can do it myself, and we have a practice of calling in about a month to see how you're doing. And in many instances, folks will say, please help me. Why? Because it's hard. And it's something folks don't want to do because it's hard. Candidly, a lot of institutions, especially the larger ones like banks, the person you're dealing with first, maybe second and third, have no idea what you're talking about. So there's a lot of holding on the line. There's a lot of back and forth to get these properly funded into your trust. So a lot of folks will initially think that they would like to do this themselves, and then will come back to us and ask to hire us to do that, which we're happy to do. Happy not because it's enjoyable work, but happy because of the importance of the work. It's frustrating. It's very frustrating, but that's what lawyers do. And I joke that a large part of the reason we need lawyers is because whatever you've got that's frustrating on your plate, you can turn it over and put it on ours, right? This is one of the more frustrating parts of my practice. That is getting these assets properly in there. And candidly, sometimes clients aren't all that understanding about how difficult a task this is. Sometimes the instructions from the client are not all that clear. So if you do hire someone like us to do that for you, please be as clear as possible in your instructions as to what you would like to have done as far as the funding of your estate. We'll try to guide you by asking all the right questions, of course. By the way, for those of you that are new, in a moment, I'm going to take questions. And kind of the rules of the game here are, if there are questions that are broad, general, and apply to the group, I will take a shot at answering them online. If they're very let me try that again. If the question is very fact specific, something that is really a unique situation, I will suggest that we handle that not on the Zoominar, but one-to-one. So I have a few more items to touch, and if there are any questions, go ahead and type them into the chat bar, and that's about right down here somewhere on your screen if you need to ask a question this morning, anything to do with funding a trust particularly. I also have to do the caveat that this Zoominar is for educational purposes. I will do my best to answer your question within the scope of my knowledge, but if you wish to rely on my legal advice, you'll need to retain us so that we can provide that to you. So while you're thinking up any questions, and I see a how much is that. If your question is different than how much is funding, retype the question, and I'll get to that in just a minute. I do have a couple questions, but I want you guys to know before I get there that I feel so strongly about this subject that I want to make you a special offer this morning, that if you will call or email or however you want to contact us by 5 o'clock on Friday, that's tomorrow, and give us the code, ready? Funding is fun. It's not really, but we made that our code. Funding is fun, F-U-N-D-I-N-G is fun. We will not only waive the fee for your initial consultation or discovery meeting, waive the fee, so that's between a $300 and $450 savings to you. We'll also give you 10% discount on the first services for which you engage the firm, including funding if you need that. So that's our special offer this morning for all of you, and we have a large group this morning, which is awesome. And I want to make an announcement about the follow-up one, but first I'm going to try to take these couple of questions. Yes, thank you. How much is that? So in order to fund a trust up to 5 or 6 accounts or different types of transfers, we charge a flat fee of $1,000. If you get beyond that number of transfers, we have an additional fee per account. And the honest truth is, I don't remember what that is. I have wonderful people that work on my team, and they can give you a quote on that. We'd be totally glad to. I would suggest to you that it's well worthwhile and that it is a low profit margin process for my firm, but it is so important that I just decided we absolutely had to offer it. The next question, let me make sure I didn't skip anybody. Nope, the next question is, is it generic on a home, for example? If a person moves and then doesn't need updating for the new home? Man, that's a fantastic question. I wasn't sure where we were going with the is it generic. Well, happen to be a real property lawyer, right? So we're going to make the determination, and in all likelihood, we are going to move your homestead into your trust. I happen to have just had a special scenario where I gained some additional expertise on making sure that you retain all of your amazing Florida constitutional homestead exemptions when you transfer your home into a trust. I'll tell you, we were doing it well, but I happened to have the opportunity over a special exemption to have a discussion with a 30-year employee of a tax assessor's office whose job it was to read deeds and make sure they were properly titling into trust, reserving the homestead exemption. We were doing it right, I'm pleased to say, but she did offer us some additional language, which we are now including in all our deeds. So then the question goes on to say, if we move, right, because we downsize, we upsize, we do all sorts of things with our home and during our lives as Floridians. If we move, what happens? If you move, you will take title to your next home directly into the trust. And you will, oh, by the way, transfer title out of the old home into the trust. As a interesting, to me, aside, because of the homestead laws, you will transfer individually out of the trust as well. I hope that properly answered that question. That was an interesting one. Thank you. Should prepaid funeral expenses be in a trust? Great question. I have to tell you, I have not had that one before. And so I don't have an immediate answer off the cuff for you, but I believe that we'd have to review the contract between you and the provider, the funeral home, and determine whether that is an asset which can be held in a trust or whether it should be left individually. That contract may be an individual one between you and the provider, so we might elect to leave that one out, but it is absolutely something we should look at, as are all assets of that type. Excellent question, and congratulations to you, by the way, on having prepaid funeral expenses. Stay tuned. We are about to do an event with one of the largest, maybe the largest in the country, providers in that space. And we are actually going to do a live event seminar If you want to know about that, please contact Shelley or any member of our staff. info@rocksolidlaw will get you there, but also Shelley, and that's the last half of Michelle, so that's C-H-E-L-L-E, Shelley, at rocksolidlaw.com. One more time, C-H-E-L-L-E. Think of it as the last half of Michelle, my belle. I think that's the first time I sang during one of these. Next question. Oh, that might be my favorite one of the day. Yes, sir. These sessions are all recorded and they are uploaded to our website, which is rocksolidlaw.com. You can look for the button that says videos, which I think is at the top of the page, but you can also just put rocksolidlaw.com/videos and it'll take you right to the menu, and all of these are there. And of course, when you're finished, and you have questions, there's a info at button. The next question, how is obtaining financing for a home purchase affected when putting property into a trust? Man, that is an awesome question. If it is a revocable living trust, most mortgage lenders will see that as a see-through entity, and so you will be able to close your loan in the trust. They may wish for you to also sign individually as to the obligation. These are rules of each particular lender. And if you ever run into a scenario where you're having difficulty with that, somebody who's knowledgeable in it, like us, we have, I will say it this way, we regularly have the opportunity to educate lenders on trust matters. Now, if it is an asset protection trust, an irrevocable trust, they may not lend to you unless the trust itself is creditworthy. So that's a whole nother issue, which leads me to the remark that a revocable living trust that we've been mostly talking about today and funding it does not have any asset protection component to it. You have to go to an irrevocable trust to have asset protection from the trust itself. And there are many, many, many kinds of trusts that offer asset protection. All trusts, however, need to be funded. So there's the fun in funding that we need to do it for all of them. I am being educated that there are no backslashes in URLs. They're all forward slashes. So apparently I have misspoken myself this morning. Had a law school dean use that term teaching a class on the Uniform Commercial Code, which he helped to write, say that he'd misspoken himself. So /videos. Thank you, sir. Let's see. The next is, how often should a trust be reviewed due to law changes? Do you notify your clients of such law changes? Okay, there's 2 or 3 questions in there. Excellent question. In the event that there is a major change in the law, we are absolutely going to reach out to our clients and suggest that we have a review session. We also reach out about every 3 years, contact our client and say, it's time to look at any changes that have occurred in your life. We also ask our clients at the end of the process of putting their trust into effect to please contact us if there are major life changes, such as making a lot of money, losing a lot of money, having a new child in the family, having a death in the family, a marriage, a divorce. All of those big life changes, following them, we need to review the estate plan. You know, it could be as small as a falling out with someone that you had named in your documents. If you've had a falling out with a person that you put in as your healthcare surrogate, maybe you don't want them talking to the doctors when you're unable to respond, right? So we're going to reach out regularly. That's our practice at Rock Solid Law to do that. There are not that often are there big changes in trust law, but we do. I am a member of what's called Reptile, which is the real estate and trust section of the Florida Bar, and the acronym is Reptile. Well, we kind of think of ourselves as alligators. You can do with that what you will. I am not a University of Florida grad, but of course Gainesville's not far away. We try to keep up We circulate literature, people write articles on changes in the law, and we try to stay on top of that. And of course, notify our clients. If you are not receiving our email blasts, please go sign up at the website. We try to make them very educational. We offer you opportunities for more education like this. And some of them are just articles themselves. Others of you may know that I am the special magistrate for Neptune Beach and write a monthly column entitled Judge John. And it is issues of interest for people in the beaches community. So if you have an issue particularly of interest to folks that live, work, play, love the beaches, please submit them and I will consider them for a response. And those are published in the Ponte Vedra Recorder, and then of course we load them up online as well. Let's see, did I get all of those issues in that question? I think I did. Sir, if I missed anything there, let me know. So really, we are asking the client to be on guard for reviews, for changes in their lives which would require review. And then we are watching out for, on the legal side, if there are changes which might require some clients to come in and consult. It is very, very important to continually update your estate planning documents. Consider it like driving a new car off the lot, or especially a used car off the lot. You know it's going to need maintenance. It's going to need gas. It's going to need oil changes. You know, you're going to have a mechanic tune it up periodically. And every now and then it needs an overhaul, right? I laughed about a client the other day who needs an engine changed. It's unfortunate, but their trust has been in effect for decades and has been amended so many times that it's really kind of a Frankenstein monster at this point. All right, I've got a couple more questions. Thank you guys, you're so interactive today. I usually try to get off before 9:30. I know I was a few minutes late with my trouble getting on this morning, but I'll stay on as long as you guys do have questions. So if a qualified plan does not transfer to trust, please repeat how the beneficiary statement for an IRA plan should be stated. Yes, when you do your trust with us, and I think most qualified practitioners do the same thing, we will create a certificate of trust, which is, you know, a trust is a longer document, of course. It's a complex entity. But this is a 2-pager, really a 1.5-pager, and it has the name of your trust on it. So in the specific instance of a qualified plan, in all likelihood, I'm sure there are exceptions that prove the rule, but in all likelihood, you are going to not own that within your trust, but you're going to make the payable on death or transfer on death language the exact title of your trust, which is contained in that certificate of trust I just mentioned. You know, it's just like who is the beneficiary of a life insurance contract. It is just like who is the an individual beneficiary of a bank account. When you're not around to use it anymore, you put who gets it next. Well, instead of your wife, your kid, whoever it is you might want to put in there, you're going to put the name of the trust. And typically, people managing qualified plans are familiar with this process and should be able to help you revise that beneficiary language. Sometimes you can do it online. Sometimes you got to call them. There's just all sorts of ways that it's done. And that's why, you know, funding is not fun. It's frustrating. Okay, I got another question. You guys are great this morning. You mentioned not making trust beneficiary for life insurance, but it runs through it. Please explain. If I said that, ma'am, I'm wrong. Not the life insurance policy will not be owned by the trust. It will be owned by you individually. The policy will remain in your individual name. What I intended to say, and what is correct, is that you can make your trust the beneficiary of your life insurance policy. So it will be the beneficiary for a life insurance policy. Oh, I think I know where the confusion lay. I was trying to give an example of someone who might make a choice for a specific life policy to go immediately to an individual because of the facts of their particular situation. I certainly did not mean to indicate that the trust could not be the beneficiary of the life insurance policy. It can and it should be. Why do people put their homes in a trust? Wow. A little beyond today, but I'll take a whack at it, okay? They put their homes in a trust so that there is no transfer after their death. There's no issue. Of course, there is no step up in basis on inherited homestead property at this point in time under the law. But there is absolutely no issue of transfer on death at all. In other words, the very minute that you leave this earthly coil, there's no effect on the ownership of the real property. It goes immediately to your heirs. So because it's still owned by the trust, and rather than John being trustee owning it, it would be the next trustee that I've decided to appoint owning it. So there's a continuity of ownership there. There's no transfer of it at all. There's no, homestead is not part of the probate estate, but you got to go to court to get an order that says so. Okay, so it's kind of a little backwards, right? There is an extra step required there. So the continuity of ownership, putting it in the trust, and that way it is treated as part of your entire estate as your trustee considers who's going to own what assets later in time. There are also other reasons to do it. There are land trusts that can be used, but that's a little beyond what we're doing today. That's a little more sophisticated. The real reason is you can own it in a revocable living trust, and it's no different than owning it yourself, except that you're avoiding probate when you die. You can also do that with what's called an enhanced life estate deed, but that's not today's subject either. I think there's a video on that. And that the intended heirs will become owners of that property by being beneficiaries of the trust immediately after you've taken your last breath. Man, you guys were fantastic this morning. I'm sure I'm going to get demerits. Oh, I got another question. Demerits from my staff for going over time. But like I said, I'm here to answer your questions. So does that mean that the basis of the property at time of death, the property goes to a trust, the basis of the individual or the fair market value at the time of death? It's going to be the basis of the individual. And that basis doesn't change by moving it into your revocable living trust, and that basis will carry on. Interesting, I have that issue right now when we're making sure that we get a step up in basis for this party, but that was I'm sorry, I shouldn't have brought that up because that was a transfer in, out, and then back into a trust. So it was a little bit of an unusual circumstance. So I hope that answers all those questions. You guys have been absolutely fabulous this morning. I'd like to reiterate, if you call or email us by 5 o'clock on Friday and give us the code Funding is Fun, we'll waive the fee for your initial consultation and discovery meeting and give you a 10% discount on the first services for which you engage our firm, including if you need to fund your trust. Okay, the big announcement ending the day is after today's Zoominar, we're going to go to a bi-weekly program next starting on July 9th. So mark July 9th as the next one. The subject on July 9th is the senior homestead exemption. Obviously, this is important for retirement planning and estate planning, and it's also tied to our real estate practice. In Florida, we give our seniors an extra exemption against homestead taxes, home-only homestead taxes. I look forward to sharing that information with you then. Since I won't see you here on the web, between now and then, I wish you all a very happy and safe Independence Day. Please isolate responsibly, socially distance, and let's all get through this together. Again, I'm John Miller. I'm the founding attorney of Rock Solid Law here in Jacksonville Beach, Florida. I'm going to leave you with the legendary and fabulous Commodores from Tuskegee, Alabama, my old hometown. Song's called Zoom for those of you that are participating the first time. Live long and prosper.